Welcome after our lunchtime meeting on the freedom of conscience, the tension between laicity and religious minority in state and family issues. That's a long title to say that. Today we're speaking because of the report of Mrs. Sal and because of the debate tomorrow on the tension there is between states that on the one hand would like to educate children and sometimes would like to have an education which is free of any value judgment. On the other hand, families which would have the sincere wish that their children are being born and raised in a certain case. To start off with, even in my own country, that causes a huge tension when the Turkish government asks questions about a Turkish child being of Muslim origin being placed in the foster care of two homosexual parents. To give people one issue where the tension arises. It does arise in most of our countries, and that's why I think we should talk about it. Today we have three guests: Professor Marco Ventura from the Catholic University of Leuven, Peter Gramatikov, he's doctor of the Universal Orthodox Church, and the third guest is Christian Paterel. He won a court case at the European Court of Human Rights on this issue, so it's very interesting to look at the practice. First, over to you.
Thank you. Good afternoon, everybody. I've been invited to offer some overview on European guidelines, which can be of help as you prepare to take decisions on the issue of what I've defined religious diversity rights in my title. I will briefly tackle my topic in 4 steps. 3 first points are about clearly defined principles within the Convention on Human Rights, the Council of Europe, and especially through the jurisprudence of the European Court of Human Rights here in Strasbourg. State neutrality and impartiality, no state assessment on beliefs, no belief-based discrimination. The 4th point would be more specifically related to the debates on what religion is good and what religion is bad, and to what extent the state can, based on such a statement, policies and actions, and that would be a point about the admissibility of state cult prevention. First point is about how the European Court of Human Rights define the attitude of the state towards religion. We have a seminal judgment given, as you can notice, a few weeks before 9/11, it was the end of July 2001, on a Turkish case, and at that occasion the European Court of Human Rights defined for the first time what the attitude of the state is about when religion comes to the fore. And the state's role is defined in these terms. The state's role as the neutral and impartial organizer of the practicing of the various religions, denominations, and beliefs is conducive to religious harmony and tolerance in a democratic society. So this is my first point and principle: neutrality and impartiality. Then the second principle is that the state has no competence or legitimacy in assessing beliefs. This point was made several times by the European Court of Human Rights in very different cases, under very different circumstances. This is a definition of this principle based on the Manousaki's decision in 1996. The right to freedom of religion, as guaranteed under the Convention, excludes any discretion on the part of the state to determine whether religious beliefs or the means used to express such beliefs are legitimate. Then my third point is about another key principle: no discrimination, no religion-based discrimination. The Court of Human Rights applied this principle again many, many times based on Article 14 of the Convention, combined with Article 9, sometimes Article 8, sometimes even Article 6. We have here a very recent decision 2 months ago, which relates to the issue of children's rights, parental rights, custody, and especially here access rights. In this case, the father was denied the right to access to his child based on an in abstracto judgment on his belief. He was a member of a small faith community, and this membership was equaled by the Hungarian judge as something bearing an irrational worldview. And this irrational worldview, in the view of the Hungarian judge, made him incapable of bringing up his child. Now, this Hungarian decision was overturned by the European Court of Human Rights and found incompatible with the European Convention of Human Rights. This is just the end point 2 months ago of a long and well-established jurisprudence in Strasbourg that when religion comes into account in parental conflicts, only the actual harm concerning children can be taken into account, no matter what the relation of the harm or the actual threat to the children bears with religion. So religion cannot be considered theoretically in abstracto as a ground for making differences between parents. This was established, I will show you the next slide, into decisive cases, both concerning Jehovah's Witnesses' parents, and the courts made clear that in abstracto it is contrary to European law. This is the Paloma Martinez case, it's a French case. It is contrary to European law to rule in abstracto and on the basis of general considerations without establishing a link between the children's living conditions with their parents and their real interests. Which means, as established in Hoffman versus Austria, that a distinction between parents based essentially on a difference in religion alone is not acceptable. So the difference here in terms of protection of the best interest of the child is not between protecting the interest or not. The difference is protecting the interest based on evidence or protecting an interest based on an assessment of what religion is good or bad for the children. This is the point in this kind of issues. Hence my conclusion, this is my final point. We have, as such, no decisions by the European Court of Human Rights on this specific point, on cult prevention. So this is my personal conclusion, based on principles established within the European Convention, as well as in European law at large, if we consider developments in EU law as well in this field, and of course our common constitutional traditions, that these two attitudes by the state are incompatible with the European Convention on Human Rights. First, a state distinction between religious denominations and sects with regard to the principle of discrimination and state neutrality and the protection of the interest of the child and parental rights. And second, state cult prevention through labeling, listing, and targeting on individuals and groups based on their alleged, presumed sectarian membership. This is also incompatible with the European Convention. Thank you.